Now, the prosecutor obviously has the discretion to either retry the case, or they could negotiate the case, or they could just dismiss the case. They're not going to dismiss a double homicide where you're looking at the death penalty. They're just not going to. And Melly probably isn't going to take any kind of deal, because any kind of deal that they would give him would be life without parole, and he's not going to do that. Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal defense lawyer, which means I'm experienced. I go to trial. I don't just hold your hand and write passports to prison. I am a board-certified criminal defense lawyer by the National Board of Trial Advocacy and so I'm double certified by the Minnesota State Bar Association as a criminal law specialist and a criminal trial specialist. So, and I've been in these situations. Today we are going to be reacting to the Melly case and talk to you about what it means to have a mistrial and what it means to have a hung jury. But before we get to that, go to contractscounsel.com if you either need a lawyer, or if you are a lawyer and you want to do some work where you can make a little dough from home and write contracts for clients who need your services. So go to contractscounsel.com. That's contractscounsel.com. And you can help a lot of people. We got plenty of clients, but not enough lawyers. So go to contractscounsel.com if you are in fact a lawyer, and if you need more information about it, just hit me up. We can get you set up, or go to the link down below and contractscounsel.com. So we're going to react to Melly. First, if you remember, about 7 hours into their deliberation, the jury had a question, and so let's go to the question first, and then we'll kind of dovetail that into what is going to happen later. The judge received a note earlier in the week, last week, in the Melly trial. And whenever and a lot of times jurors have questions, and they can be anything from as mundane as, can we get another copy of the instructions, or can we get something to eat, or, we want to see a piece of evidence. And in this case, they have a question about being deadlocked. So let's see what the question is.
What I want to do is, based upon, I received this juror inquiry form that is signed by the foreperson that reads as follows. State of Florida versus Jamel Devins, case number 19-001872 CF10A. Check the box, ask the following question. What if we can't come to a decision? Everyone is stuck on which side they've chosen, signed by the foreperson.
So whenever they ask a question, sometimes if it's an innocuous question, the judge can just deal with it and send a note back. Like, can we get a transcript? And the answer would just be no, because there is no transcript. But in this case, when they have something like this, everybody has to be assembled. So they bring everybody back into the jury. The defendant is in the jury, or in the courtroom, the defense lawyers, the prosecutor, and the judge. And then they do it in open court. They read the question. Now, they've only been, at that point, when the judge got that question, they've only been deliberating for about 7 hours. That's not really enough time to create cause a mistrial. So let's see how the defense reacted to that.
Makes decision that Mr. Adelstein brought something to my attention out of the Thomas case, which is a Supreme Court case, and it says, as noted, every Allen charge issue must be decided upon the particular facts and circumstances surrounding an individual case. So that goes to the issue of individuality and whether or not it should be tailored to the circumstances of the particular case. And we're taking a position that mirrors what the Supreme Court has declared, that modification of Allen charges is not foreign. As a matter of fact.
So what he's talking about is an Allen charge. An Allen charge, Allen is just a case. And whenever you hear like a Frank's hearing or a Daubert hearing, or in this case an Allen charge, they all relate to a particular case. And an Allen charge is basically the judge saying, okay guys, I know you think you're deadlocked, but you need to put a little more effort into this, go back and deliberate some more. So let's see. So we'll listen to the charge.
The Supreme Court has directed that it should be tailored to the circumstances surrounding an individual case, so that we maintain our objection.
Thank you.
Thank you, sir.
So you want to bring the jury in?
Yes, sir.
Thank you. counsel, the assistant state attorneys, and the ladies and gentlemen jury. Ladies and gentlemen, two things. First, I received a note, or my bailiff did. It's not signed by the foreperson, but it's a note that was handed to him. It says, "Are we allowed to have Apple Watches?" Someone has one from one of the
And that's probably somebody being a tattletale in the jury room.
members of the jury. As I tried to explain to you earlier, all the electronic devices are basically, you're not allowed to have those in the jury room, so we asked our bailiffs, Gary, to try to collect them. Does anyone have an Apple Watch, yes or no, in their possession? I asked the question, does anyone have one? No? I see everybody raising their hands, or several raising their hands showing they don't. All right, there's no Apple Watches. Thank you.
So that's kind of a dick move if somebody did that. Otherwise, whoever has the Apple Watch is not being truthful to the court, and they're putting it in their pocket. That's interesting.
Following question. What if we can't come to a decision? Everyone is stuck on which side they've chosen, signed by the foreperson. All right? So what I'd like to tell you, or read to you, is an instruction that's called Jury Deadlock 4.1. And it reads as follows. I know that all of you have worked hard to try to find a verdict in this case. It apparently has been impossible for you so far. Sometimes an early vote before discussion can make it hard to reach an agreement about the case later. The vote, not the discussion, might make it hard to see all sides of the case. We are all aware that it's legally permissible for a jury to disagree. There are two things a jury can lawfully do: agree on a verdict or disagree on the facts of the case. Excuse me. There are two things.
So when you're back in the jury room, and and like he says, a lot of times an early vote makes it difficult for you to change your position later on.
That a jury can lawfully do: agree on a verdict or disagree on what the facts of the case may truly be. There is nothing to disagree about on the law. The law is as I told you. If you have any disagreements about the law, I should clear them up for you now. That should be my problem, not yours. If you disagree over what you believe the evidence showed, then only you can resolve that conflict, if it is to be resolved. I have only one request of you. By law, I cannot demand this of you, but I want you to go back to the jury room, then taking turns, tell each of the other jurors about any weaknesses of your own position. You should not interrupt each other or comment on each other's views until each of you have had a chance to talk. After you have done that, if you simply cannot reach a verdict, then return to the courtroom and I will declare this case mistried and will discharge you with my sincere appreciation for your services. Ladies and gentlemen, you may now retire and continue with your deliberations.
So if they can't come to a verdict, then it's a mistrial. And we'll talk about what happens if that's the case, which it is the case. So let's take a look at what happened later.
Attorney and the ladies and gentlemen, jury. Ladies and gentlemen, you see the juror inquiry form. It indicates that after further discussions, reviewing the evidence and speaking freely amongst the jurors, we are still unable to reach a unanimous decision. So at this time, what I'm going to do is just declare a mistrial, the case was mistried, and indicate to you that how much we appreciate the fact that you were here.
So they sent a second note into the courtroom saying we can't, and I don't know how many, it was like 17 hours later or however many hours, it was yesterday afternoon that they came up with, that they just couldn't come to a decision. And so the judge declared a mistrial. What happens next? Well, when you have a mistrial as a result of this, there's no conviction, right? But the charges are still there pending. So it doesn't get dismissed. So some people say, oh, you only need one juror to, no, you don't. You need all 12 to go guilty or not guilty, either way. Now, the prosecutor obviously has the discretion to either retry the case, or they could negotiate the case, or they could just dismiss the case. They're not going to dismiss a double homicide where you're looking at the death penalty. They're just not going to. And Melly probably isn't going to take any kind of deal, because any kind of deal that they would give him would be life without parole, and he's not going to do that. So, in all likelihood, they're going to have to try this case again. And where does Melly go when he's doing that? Well, he sits. He sits in jail like he has been this whole time. And how long has he been in custody? A long-ass time. He's been in there a long, long time. Now, can the defense move for bail after this? Sure they could. But I don't think... nothing's changed except for the timing of things. And one could argue that he's been waiting so long that he's, presumed guilty before innocent. And that is... But the court has the obligation when somebody is on a case like this to deny bail, generally speaking. And not an obligation, but that's how they come down. If they deny the bail, they can't be wrong. If they side with the prosecutor, they can't be wrong. You don't want to be soft on crime and be looking at re-election. And so it's an elected office. It's a public office with a public persona, and this is a high profile case. He ain't getting out. Period. Then after this, we got a little bit of a color play-by-play from the defense lawyers. Let's see what they have to say.
Just had the mistrial called, and I need to have both of your reactions.
Obviously, we want to thank the jury for their great efforts that they've extended over this period of time. But we are somewhat disappointed that Melly is not walking out the door with us. That's all I can say for right now.
And David, do you have anything you want to say further?
I don't really have much to add except to say that the jury did pay attention. We asked them to do a lot, and they hung in there and gave it its best effort, their best effort, and it's the most we could ask of them. So.
And what are your next steps as far as Melly is concerned? Are there going to be any efforts to try to get him out on bond?
We're not at liberty to discuss that at this point.
What are you at liberty to discuss? Can you tell us anything about next steps?
No.
Okay, thank you so much. We really appreciate you coming.
I like that. I like less is more. There's some guys who get out there and, grandstand or whatever, but these guys are to the point, and, both lawyers, I think, did a tremendous job. And I don't know if this is true or not. I think Melly's mom has said something like that the verdict was 9-3. I don't know how she would know that unless she talked to one of the jurors but here's the thing. Once the jurors are done with their service, they're done with their service. So these defense lawyers and the prosecutors could go talk to those jurors if they want to now, because they're not going to, when they convene a new trial, different jury altogether. And the nice thing about that is you can see what worked, what didn't work. And that would be very instructive for a new trial. So this has been our reaction to the mistrial declared in the state of Florida versus YNW Melly. We'll see you next time here on Criminal Lawyer Reacts. I'm Bruce Rivers. Make sure you go to contractscounsel.com if you are a lawyer, because they need lawyers. So go to contractscounsel.com and make sure you sign up for Patreon, follow us on Instagram, follow us on Twitter. Sign up for everything that's on our thing, because we suck. No, I'm just kidding. Make sure you follow us on Instagram, follow us on Twitter, subscribe, sign up for Patreon. We'll see you next time here on Criminal Lawyer Reacts. Hi, this is Bruce Rivers. Welcome to another fun-filled, quick episode of... What is this? Oh, it's Criminal Lawyer Reacts, CLR. I'm Bruce Rivers, board-certified criminal defense lawyer, coming to you live with my pearl handle pistol cufflinks given to me by our content genius, Michael Rivers. So today, it's going to be a quick video. So remember we talked in our last video on the gift that keeps on giving, Andrew Tate, about certain text messages. We're going to talk about that in a second, but before we do, let's say you're Andrew Tate and you need to get your medical records over to the prison staff and you don't know how to sign a release of information. Well, you're in custody, but you have a laptop and they send you a document and you e-sign it, so you don't have to leave your cell because everybody else wants to do what they want to do to you. And you're able to get those release of medical records so you can pretend you have some kind of condition so you can get out of that prison cell, because it just sucks. You go to esign.com, get the app. You get 3 signatures a month for free. If you do that, you'll be good to go. You can do it for anything else, retainer agreement or business agreement or any kind of contract that you want to sign remotely. Remember I was talking to you a little bit about these women coming forward with these messages and I love everybody that comments, whether it's positive or negative. And we've, and some of you guys, you're just super loyal to Andrew Tate, and I think that's well. You got to have somebody that you're loyal to, right? Not me. I mean, am I biased? Yes, I'm biased, because his words make me not like him. But that doesn't matter, because what matters is, what is he going to face, all right? And what is the evidence out there? So I can give my opinion all day long, but does it really matter if the evidence is not there? Does it really matter if the evidence is there? Let's just give it to you straight. Remember, he says, "I love you." Let's play. I haven't heard this, and I know what you guys are going to say. I know what you people who have one ball in each hand.
You didn't like that I was thinking I can do whatever I want to. That's what it is. I'm the smartest person on this planet.
That's a voice recording controversial influencer Andrew Tate.
No way, man. That's AI. That's AI. There's no way he would even say that.
A woman in 2015. That audio, along with disturbing messages reading, quote, "I loved raping you," are now coming to light as Tate faces sex trafficking charges overseas. Vice World News published the messages and voice notes allegedly made by Tate. We want to warn you, they may be disturbing to some.
All right, you ready? Now, if you're saying this is AI, that would be a great defense. And here's the thing. I've seen Elon Musk talk about how they have this AI, and maybe it is. But this is going into court. And if it is AI, you're going to have to prove it, because it'll be almost presumed that it's the real deal, because you have to have somebody lay foundation. That's how this works. So you can't just get a piece of evidence in just because you say it is what it is. Somebody's going to have to say, this is the recording of Andrew Tate, and it was sent to me. So whoever was the recipient of this, but let's listen.
Am I a bad person? Because the more you didn't like it, the more I enjoyed it.
Remember, that's exactly what I read to you in our last Mr. Tate video.
I loved how much you hated it. Turn me on. Are you seriously so offended I strangled you a little bit?
I think I'd be offended if you strangled me a little bit. Now, keep in mind, some people like that. But if you're complaining about it, you probably don't have a safe word, and you need one.
You didn't f***ing pass out. Chill the f*** out. Jesus Christ, I thought you were cool. What's wrong with you?
I thought you were cool, so I could put my hands around your neck so you could watch your eyes pop out and get petechiae eye all over the place.
And if I had actually hurt anybody, the Romanian police would have me in jail.
What? Now, is that AI? If I would have actually hurt anybody, Romanian police would have me in jail. Where are you? I think you're in jail. Here's the thing. We've only seen just snippets. And let's talk about the procedure a little bit. There's the evidence gathering stage, which is what we're in right now. And I've seen some comments, where people say, well, they've come back and they've said that they didn't do it. He hasn't had an opportunity to cross-examine anybody yet. Well, no, you wouldn't at this stage. This is the charging stage. It's the very beginning. You don't get your opportunity to cross-examine somebody before you testify or before you get charged. You get charged, then you go through pretrial procedures. Maybe you have some motions. Maybe you make a motion saying that all these recordings are AI and they're really not. And so you file a motion with the court. And then you bring the women in and she says, no, he said this to me. And these would have been recorded on WhatsApp and apparently sent to them, so they would have the recordings. And if they come in and lay foundation for him, it is an admission of a party opponent. So it comes in as his own statement if it has sufficient indicia of reliability. That's kind of the standard. So this is just our little kind of follow-up to what we said before about these messages. And so, because, you know, we report as we get information, and if it doesn't make sense, I'll tell you that. You know, do I like Andrew Tate? I think he's a pig, so what? But it doesn't mean that I'm not going to give it to you straight. I'm not going to lie to you about Andrew Tate. I'm going to give it to you the information that we have as we get it. And right now, we're going to have more and more and more and more of this stuff. Drip, 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 drip. The gift that keeps on giving. I'm Bruce Rivers. Thank you for watching us. Subscribe, follow us on Instagram, follow us on Twitter. Sign up for Patreon for crying out loud. And we'll see you. Hi, this is Bruce Rivers. Welcome to another episode of Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal defense lawyer, where I actually try cases. Today we are reacting to what do we think that cross-examination of Amber Heard is going to entail. Now, the cross-examination of Amber Heard by Johnny's lawyers has got to be artful. You can't go real hard on somebody who's super sympathetic. For example, if you're cross-examining a child witness and you go after them hard, a jury's going to hate your guts, and you're going to lose credibility with them. So Amber Heard presents as somebody who's capable. She's an adult. If you listen to some of the recordings, she's violent. And I don't think she's coming off as quite that sympathetic. So I don't know who's going to do the cross-examination of her. Sometimes having a woman cross-examine another woman is ideal. And I think that may be what we have here. Women jurors are particularly hard on other women if they can be catty and they can be really harsh in their judgment when they are of another woman testifying. So if a woman is testifying and a female juror is listening to this and not really buying the story, that's going to bleed into the rest of the case. So her lacking credibility, her meaning Miss Heard, will not only hurt her own counterclaims, but it'll also help Mr. Depp in his claims to begin with. So what do they have to do? What do they have to do? Johnny Depp's lawyers have to, number one, refute the counterclaims. Number two, they also have to discredit her on her claims of abuse. There's going to be a lot of cross-examination on that part of the case. The issue here with Amber Heard is one of efficiency, because there's so much material out there and there's so much that they could do. Johnny's lawyers have to defend against the counterclaims, and they also have to discredit her. Those are the two main things that they have to do. And how are they going to do those two things? They're going to do those two things by presenting provable falsities that she's made, and there's so many of them. Let's look at a couple right now.
This was what she used. She became very adept at it. You're going to hear the testimony from Amber about how she had to mix the different colors for the different days of the bruises.
Sitting here today, do you know how much money Ms. Heard has actually donated to the ACLU, actually remitted to the ACLU?
Yes, I do.
How much is that?
So when you say remitted, do you mean direct payments from her personally, or?
One of the things, you know, a witness's demeanor tells more than anything else on the stand. So when Amber Heard is crying on the stand and you don't see any actual tears, that's a tell. And women will know that. Not everybody reacts to trauma the same, okay? And that's pretty, I think that's, the literature shows that, and that's just common sense. I mean, I've had witnesses that literally laugh when they get nervous. And you might think that they're being disrespectful, but it's a nervous tick, you know. But what I'm trying to get at here is when Amber Heard's in court and she's crying, and there aren't tears coming out. And she's talking about things that just are irrelevant details, but they're overly enunciated. She can lose credibility. So on cross-examination, you want to bring out two things. One, to show that she was the abuser, and two, that she's a liar. That's what Johnny Depp's lawyers are going to do. So how are they going to do that? Well, there's so many recordings on this that, they've got a real gold mine to bring up. And so what they're going to do is this. You've got the one audio where Johnny Depp is talking to her, and I think this is the most damning video or damning audio that there is out there. Johnny Depp says to her, if this ever gets physical, we have to separate. We have to walk away. And she says to him, I can't promise that I can do that. That's one. I think that's the most damning audio out there for Amber Heard. But we also have other things. She pledges to the ACLU and Children's Hospital $3.5 million each. Johnny Depp made the first $100,000 donation, and then she said on openly that she has done that, but it's just simply not true, and they'll play a portion of her prior statement, and that comes into evidence. And she'll have to say it isn't true, or she's going to spin it and say, well, it's a planned future donation, and she hasn't donated one penny since then. And so when she tries to say that, I 1.3 million of the total donation has been made, she didn't make any of it. Elon Musk and others have made donations in her name. So, but she gives the impression that she's the one donating. That's a mark on her credibility. Then, in her opening statement, Amber's lawyer held up a compact or a makeup kit and said this is what she used for to cover up the scars, cover up the bruising. And it has been shown that that particular makeup kit wasn't even manufactured until after they were divorced in 2017. So they'll bring up things like that, and they'll bring up the recordings, and they'll bring up one of her common complaints for Mr. Depp was that he was constantly running away. That will be a recurring theme in cross-examination. And the reason that is so important for the plaintiff in this case and counterclaim defendant, Johnny Depp, the reason that's important is because that shows an utter lack of aggression. It shows a separation. It shows somebody who doesn't want violence. And she's constantly complaining about him doing that. So we kind of see what the mission is for Johnny's team as they go into this week to cross-examine Amber Heard. It'll be an art because there's so much there, but they have to be careful not to ask too many questions, not to ask the wrong question, not to leave her any chance to explain. And then once they're done with that direct or cross-examination, then her lawyers get another opportunity for a redirect. But that redirect examination has to be focused only on what Johnny's team has cross-examined her on. But then Johnny's team gets one more chance on recross, and they narrow. There's ostensibly it could be limited, unlimited. Direct, redirect, recross, redirect, but the issues get narrower as time goes on. So it'll be fascinating to watch. I'll be watching. So when you watch this reaction and you watch the actual cross-examination of Miss Heard, comment. Tell us what you think. And subscribe to our channel. Follow us on Instagram. Follow us on Twitter. And we'll see you next time here on Criminal Lawyer Reacts. Hi, this is Bruce Rivers. Welcome to another episode of Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal defense lawyer, coming at you with my pearl handle pistol cufflinks. And we're going to react today. There's just so much going on with Donald Trump that it's in his circle and there's so much legal going on. We just have to react to it because it's absolutely fascinating from my standpoint. But before we get into that, I want to let you know that this episode, as most of our episodes, are brought to you by eForms.com. That's eForms.com. If you are looking for a form or power of attorney, a loan agreement, anything, any forms legal, go to eForms.com so you don't have to hire a guy like me, spend a bunch of money to draft some form that you can get on eForms.com. So go there, and I highly recommend it because I actually use some of their forms myself. So today we're going to react to a bunch of stuff going on with Donald Trump. Let's just do a recap. Here's the thing. I have clients all the time that wind up getting case after case after case after case, and they're very hard to manage. Because you have one case, and you can look at it and say, I could beat that, but then you did this, and I have no defense to this, so I'm okay here, I'm fucked over here. Well, Donald Trump has so many irons in the fire. He's got, I think, approximately 20 civil lawsuits that he's currently fighting. He has the AG in New York after him, along with the district attorney in New York. He also has the DOJ in Washington, D.C. after him. And he also has the DA in Fulton County, Georgia. Let's kind of break those down. The DA and the AG in New York had him sit down for a deposition, basically. And I think they had about a dozen lawyers talk to him and ask him questions. And other than his name, guess what he did? He took the Fifth Amendment on every single question that was substantive, except for his name. Now that he's entitled to do that, and that's probably the smartest thing that he's done so far. The problem is, in a civil case, so if they're going after him civilly for all these back tax damages, when you take the Fifth Amendment, it is not painless. It comes with a price. When somebody takes the Fifth Amendment in a civil case, whoever the fact finder is can draw an adverse inference from that. And what that means is they can look at the fact that he did that and think, oh, he's got something to hide. So the answer to that question must be the opposite. In other words, it's got to hurt. The answer's got to be in the negative, towards Donald Trump or anybody else who takes the Fifth. So let's just kind of look at what it means. So I'll give you an example. So if you sit down to the deposition and isn't it true that you inflated value of your property to get favorable loans, and then you use that same property and deflated it to get a different tax value on it to save money on taxes? Now, if you answer by taking the Fifth, then the answer is whatever negative implication you get from either one of those. Now, in a criminal context, that cannot be held against you. So you have the absolute right to remain silent, and criminally, the jury cannot draw an adverse inference from that. So that's what that means. So I think he's in some deep financial trouble in New York, no question about it. And what he did in New York was he's got several properties, and for tax purposes, they reduced the value, they took depreciation and said it wasn't worth, X. And for loan value, they pumped it up, and you can't do that. You have to be truthful in both contexts. If you're lying in both contexts, you can be held criminally liable for that. Now, let's skip D.C. for a second, and let's go down to Atlanta, Georgia, the Fulton County DA down there. She's investigating the election fraud and the interference with the election, where Donald Trump actually said, I need 11,000 votes, fellas, come on. And he really did some pressuring.
I only need 11,000 votes. Fellas, I need 11,000 votes. Give me a break.
And so in that case, Lindsey Graham has been ordered to testify. So now Rudy Giuliani not only has been ordered to testify, he's been notified that he's also a target in that investigation. See, you can't just go around making bullshit arguments all over the place, all over the country for that matter. That's why he lost his license. things that just aren't true. You can't say things that aren't true in front of a court. And so he most certainly will take the Fifth Amendment in front of the grand jury. And when you do that, they can't draw an adverse inference. They can't use it against you later. If you testify and you say things that are true or untrue or whatever, that's fair game. They can use that against you any way they want later. But they can't use your Fifth Amendment constitutional right to remain silent against you. So those are pretty major things, just those two. But let's talk about what's going on in D.C. The other thing we didn't talk about was, remember Michael Cohen? Michael Cohen pled guilty to campaign finance laws, and I think he got 3 years as a result of it. And he got out of prison a little bit early, but who was he acting on behalf of, and why did he plead guilty? He was acting on behalf of Donald Trump. So that case is still live, and Trump does have some exposure there. Let's react now to Merrick Garland. Merrick Garland is the Attorney General of the United States. And I did a reaction to the raid that they did on Trump's home. It wasn't really a raid. I mean, they executed a search warrant. Now, to get a search warrant, someone has to write an affidavit up establishing probable cause. And probable cause that a crime was committed and that there's evidence of that crime in the place to be searched. It has to articulate with specifics what is to be searched and what is to be found. We know for a fact that there were one or maybe two informants that were part of that search warrant, or the search warrant application. There's a search warrant, a receipt, inventory, return, that has all the things listed on there, and then we have the application for the search warrant. So they've released the search warrant itself. They have not released the receipt, inventory, and return, I don't think. Trump could certainly do that because he most certainly would have gotten that. And then you've got the application for the search warrant, and that is now sealed. Trump's team has moved to unseal it, and the government is trying to keep it sealed, stating that it's part of their investigation. But let's watch Merrick Garland's press conference.
Good afternoon. Since I became Attorney General, I have made clear that the Department of Justice will speak through its court filings and its work.
Which is what they should do. And remember, this came out a couple days after I did my reaction, and I told you that he would come out and have a statement a couple days later.
Just now, the Justice Department has filed a motion in the Southern District of Florida to unseal a search warrant and property receipt relating to a court-approved search that the FBI conducted earlier this week.
The search warrant is the actual warrant that the judge signs. The receipt is the items found.
Copies of both the warrant and the FBI property receipt were provided on the day of the search to the former president's counsel, who was on site during the search. The search warrant was authorized by a federal court upon the required finding of probable cause.
So, like I said, you cannot, and when you're dealing with a former president, I guarantee you, if they didn't have their I's dotted, their T's crossed, they wouldn't have gotten this search warrant.
The department filed the motion to make public the warrant and receipt in light of the former president's public confirmation of the search, the surrounding circumstances, and the substantial public interest in this matter. Faithful adherence to the rule of law is the bedrock principle of the Justice Department and of our democracy.
So there have been a lot of talk about the judge is tainted, the FBI is tainted, that Merrick Garland is a traitor and he's tainted, everybody's tainted, but except for Trump is just Mr. Whatever. No, it doesn't work like that. It just doesn't work like that. You got a federal judge and you have a process that they have to go through. And I know there are going to be some people who, are drinking the Trump Kool-Aid. Fine, I understand that. But what's going to happen is, you see, this will result in facts being found out. And there were 3 statutes that were implicated: the espionage statute, the Presidential Records Act, and obstruction of justice. Those 3 statutes.
Much of our work is by necessity conducted out of the public eye. We do that to protect the constitutional rights of all Americans and to protect the integrity of our investigations. Federal law, long-standing department rules, and our ethical obligations prevent me from providing further details as to the basis of the search at this time.
So the whole reason for that, let's say they do this search and they had information that was bad. In other words, their application for the search warrant contained information they thought was true at the time they did their search, and that what they were looking for is not there. And so they've done this search, and if they have gone off half-cocked, that they would have besmirched somebody who was not guilty of a crime. So we want them to kind of hold their cards to the vest.
There are, however, certain points I want you to know. First, I personally approved the decision to seek a search warrant in this matter. Second, the department does not take such a decision lightly. Where possible, it is standard practice to seek less intrusive means as an alternative to a search and to narrowly scope any search that is undertaken.
So let's talk about that for a second, that less intrusive means. First of all, they asked for the documents. They received a bunch of boxes of documents. Then they were told that there's more there. So then they sent a subpoena, and they were negotiating a subpoena with those lawyers. Deaf ears. So nothing happened. They didn't respond to the subpoena. So the only measure that is available to them is to execute a search warrant if they have credible information, which it seems like they did.
Third, let me address recent unfounded attacks on the professionalism of the FBI and Justice Department agents and prosecutors. I will not stand by silently when their integrity is unfairly attacked. The men and women of the FBI and the Justice Department are dedicated, patriotic public servants.
Here's the thing. I've had a lot of cases over 25 years with the FBI. I do a lot of federal work, and I can count on one hand the number of times I caught an FBI agent in a lie. And even then, I don't know that it was a lie, but it was certainly not telling the whole truth in court. But 99.999 times out of 100, here's the other thing. They're super motivated, they're super fucking patient, and they know what the hell they're doing, and they're very well educated. Here's the thing. They don't need to go out looking for business. Business finds them, right? But right now, there is this anti-law enforcement culture out there, and there's people saying just kind of awful stuff about law enforcement. And believe me, I'm not a super fan of law enforcement. It's what I do to oppose them, right? But I don't think you should threaten their lives.
This is all I can say right now. More information will be made available in the appropriate way and at the appropriate time. Thank you.
So I like Merrick Garland. I think he is a straight shooter. But let me ask you this. So you also had the January 6th probe too, right? Which we haven't really talked about yet. If all these people, and there's hundreds of people that have been prosecuted regarding January 6th, that's another avenue that Trump may have some exposure to. Now, this isn't really a Trump bashing session, okay? It really isn't, because I could give a shit less whether he's the president or not. I'm more of an independent than I am anything else. I don't believe in the death penalty. I don't believe in harsh punishment for nonviolent crimes like drugs. Some of the drug laws right now are just ridiculous. But that's all politics, whatever. Who gives a shit about that? What I do care about is just a fascinating number of cases that this guy's got going on. And so the next step in this whole thing, Trump's team has moved to unseal the application for the search warrant. And the government has filed a response to keep it sealed, saying that their investigation is ongoing, that sources and methods will be exposed, and it'll hurt people. Trump wants it exposed because he wants to find out who the snitch is, and there is definitely at least one, if not more, snitches. So we'll see how it plays out. I think by this fall, you're going to have a grand jury in D.C., or maybe sometime after the midterms, a grand jury in Fulton County, Georgia, that are going to come back with some indictments. Is Trump going to get indicted? I have no idea. I wouldn't put it past the federal government to indict him. Sandy Berger was indicted, and he pled guilty to a misdemeanor. General Petraeus, he pled guilty to a misdemeanor. So that could be where it's headed. But The problem is the Espionage Act was implicated. Nuclear secrets, I think, are implicated, but we don't know. We're all speculating about that kind of stuff. But you can kind of see how many balls he's got in the air. And here's the other thing. The top legal talent in D.C. has been contacted, and they've turned him down. But that's in D.C. In Atlanta, however, now Drew Feinling, now you may remember we talked about him a little bit. He's represented Gucci Mane, he's represented Cardi B, Waka Flocka Flame, a bunch of different rappers. Trump has hired Drew Feinling. And it's interesting because Drew Feinling had criticized Trump early on. He criticized the firing of the U.S. attorney in the Southern District of New York. He said the POTUS firing the SDNY, that's Southern District of New York, U.S. Attorney Preet Bharara, is a sign of fear that he would aggressively investigate the stench hovering over the POTUS. He also criticized him over his comments on LeBron James, stating the racist architect of fraudulent Trump University, criticizing LeBron, the founder of the Free School for Children, POTUS pathetic once again. And what he says, basically, that he doesn't necessarily pick his clients. We all pick our clients. He doesn't let his personal politics get in the way of representing his clients. And he's saying that this is a politically motivated hatchet job, basically. So he does have a really good criminal defense lawyer in Georgia, and it'd be interesting to see what that contract looks like. I would bet it's payment up front. And that's probably one of the things he's most worried about. The only thing about the Georgia case, though, is that everything's recorded. I mean, everything is right there out front. So it's not a matter of what happened. It's a matter of what does it mean. I think Trump would be an absolute nightmare for a client. Not because he's got so much work for you, because that would be great. There's two things. He doesn't pay his people. You think Rudy Giuliani got paid his $20,000 a day? I guarantee you he didn't get paid a dime. Not only does he not pay his lawyer fees, he is just an awful client to manage. When this whole search warrant thing came out, he said we didn't have the records. Then he said it was a shifting target. So if you're telling the truth, your story doesn't change. But then he said, well, I declassified them all. Then he said, they're mine. He said like 3 or 4 different things. And you can just tell that Trump is in a little bit of a panic. And I think I would be if I were him, because he just has so much stuff going on. So we'll keep an eye on this. This has just been a Trump update and brought to you by eforms.com. This is Bruce Rivers, criminal lawyer, board certified. So subscribe, follow us on Instagram, follow us on Twitter, and we'll see you next time here on Criminal Lawyer Reacts. Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, criminal defense lawyer, board certified, I might add. Now, today we're reacting to the recent developments in the YNW Melly case. Now, if you remember Melly is charged with the death of 2 guys. Melly and Bortland were arrested and each charged with 2 counts of first-degree murder. Authorities say that 2 men fatally shot their friends, 20-year-old Chris Thomas Jr. and 21-year-old Anthony Williams, YNW sack chaser, and YNW juvie. Now, we've kind of go over what the facts of these are, so I'm not going to go over the facts in detail. But what's really interesting in this case is that the defense, and he's got some good defense lawyers on his side, the defense has filed a motion to get rid of the death penalty. And the judge granted that motion. Now, let's talk a little bit about the death penalty in Florida and what the aggravating factors are. And in this case, they were trying to allege that this was a gang hit. Basically, it was done for the benefit of a gang. And I said that it was weak, that was the connection to gangs was weak, because they're not rival gang members. They were friends of theirs. They were close associates. I just didn't see this as being, for the benefit of a gang. And so, in order for the state in Florida, because not every state has the death penalty, but in order for the state to proceed and to seek the death penalty, there has to be one of a number of aggravating factors. And what is an aggravating factor? An aggravating factor is something that's not present in your normal case, and it's something that heightens the severity of a case. For example, particular cruelty, a particularly vulnerable victim. And in this case, the aggravating factor that the state was trying to prove was that it was a crime for the benefit of a gang. And while, YNW Melly may be part of a gang, there was no evidence, in my opinion, and I said this in one of my earlier videos, that I thought it was extremely weak. And I'm glad to see that the death penalty, first of all, I totally oppose the death penalty. I think it's barbaric, and we shouldn't be, the government should not be in the business of killing. And when it comes to the death penalty, it's not equally enforced or imposed. And in fact, it's largely imposed on the poor and those who can't afford good lawyers. Now, in this case, we have YNW Melly, and YNW could be perceived as a gang, just like YSL, is being targeted. And there's a blurred line between something that may be a gang or maybe it's a record label. And the government in you're seeing around the country is trying to blur that line and try to say that these crimes that they're committing are for the benefit of a gang and not a record label. But in this case, the defense filed a motion, and let's just kind of read a little bit. The court has found no legal authority directly applicable to the facts in this case. As far as the court can ascertain, the issue in the defendant's motion is one of first impression in Florida. So the prosecutor intended to seek the death penalty. The prosecutor must give notice to the defendant and file the notice within the circuit court within 45 days after the arraignment. Now, the defense argued that the state is precluded from seeking the death penalty at trial because the state failed to file a notice of intent to seek the death penalty within 45 days of his arraignment on the superseding indictment. The state argues that the court lacks authority to determine the pretrial that the death is not a possibility where the state is in full compliance of Rule 3.181. However, the state is not in full compliance. In other words, actually, so what they're saying here is that the state did not comply with the rule. And the state cites no authority holding that this court cannot preclude the state from seeking the death penalty where the state has failed to comply with the 45-day notice requirement. That's interesting. All right, so this is what we call a fucking classic blunder. The state failed to give notice within 45 days of the indictment of the intention to seek the death penalty. Now, when you live by the sword, you die by the sword, right? So, I've had, deadlines jammed up my ass if you've missed a deadline. And it's a hard and fast rule. For example, you have, if you have a scheduling order and the judge says you do this by this time, otherwise forget about it, and you don't do X, Y, or Z, well, then you're sort of fucked. And here's the thing. If that screws your case and you're representing a paying client, you get your ass kicked by the client. The client now has a claim against you for ineffective assistance. Well, in this particular case, the state failed to file their notice in a timely way. And the court said it's mandatory, and it's not something that can be overlooked. A lot of times courts will say, okay, well, you didn't file a notice, but, we're going to overlook that because there was no actual prejudice. In this particular case, the court said you didn't file a notice, it's mandatory, see you later. So this is a classic fuck up by the prosecutor who just didn't file their notice on time. This would be an appealable ruling. God, because their trial is supposed to start later this year. But if the state files an appeal, a pretrial appeal of this ruling, that'll delay the case even further. And we were supposed to try this like months ago. We were supposed to start jury selection like May 1st, or I think it was May 1st, somewhere around there. And that was expected to take about, 4 to 6 weeks. And now death penalty is off the table. So that So if death penalty is off the table and they don't appeal it, then it changes the type of case that it is. So they don't have to find a death penalty qualified jury, which is a totally different type of jury selection. So, Melly's sitting there, and, before he was incarcerated, he sent to all my fans and supporters, no, I did not get locked up in Washington, but I am turning myself in today. He wrote, I want you guys to know that I love you and appreciate every single one of you all. A couple months ago, I lost 2 brothers by violence, and now the system wants to find justice. Unfortunately, a lot of rumors and lies are being said, but no worries, God is with me and my brother, YNW Bortland, and we want you all to remember it's YNW family. I love you. YNW Sack Chaser, YNW Juvie, hashtag free us. I guarantee you this particular post on Instagram will definitely be part of the trial. So one thing that we have not talked about is earlier in June here, the prosecutors are trying to, who are trying the case, claim that they've obtained evidence that shows that Melly commissioned, as yet to be revealed, person to commit a series of crimes. These include narcotics trafficking, firearms violations, and authorizing the killing of his mother. The rapper and his mom seemingly dismissed the claims on social media, while a story on Melly's official Instagram account referenced lies and false agenda regarding the rumored hit. His mother, Jamie Demons King, shared a story on Instagram that read, "This is pure desperation," on the part of the prosecutor. So, and that's according to BET. So we are encouraged by the ruling from the judge, and while this may be, they may try to appeal this, I don't think it's really an appealable ruling. I think, you either followed the rules or you didn't follow the rules. If you didn't follow the fucking rules, guess what? You're fucked. And I think that's what the judge said to the prosecutor here. So, I mean, when you got a job to do your fucking job. And thankfully, I mean, so he's dodging the death penalty here just by skin of his teeth. However, even if they were to bring it before a jury, I think, it was for the benefit of a gang. Part of it, I think, is so weak. I don't think that would have survived anyway. So that is our update on YNW Melly. Scheduled to go to trial later this year. We'll keep following up, and so you guys keep following us on Instagram, follow us on Twitter, subscribe, like, follow, spread the fucking word. Stop yourself snitching, and we'll see you next time here on Criminal Lawyer Reacts. Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, your very own personal, board-certified criminal defense lawyer, and that's you. You know who you are. I'm here just for you. Just that one person out there. Or maybe 1.4 million of you. I don't know. Anyway, today we're going to go back to our roots, ladies and gentlemen. Back to our roots, what got us here in the first place. If you go back to the very, 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 very first video that we did, where I didn't have a voice, I didn't know what the fuck I was doing, we reacted to Murder on My Mind by Melly. And so we started doing these reactions to, it was Michael's idea. We reacted to drill kind of stuff and then decoded the lyrics. So we're going to do that today with two rap songs, one by Skrilla and one by Baby Osama. Baby Osama? Okay. Grammy winner, Baby Osama. And the title is, the first one, it's a blah da 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 da. That's the name of the song. It's not very long. But before we get to that, I just want to tell you something. Come in closer. Yeah, you. How are you doing? You're probably looking for some legal advice, aren't you? Guess where you go? AskALawyer.com. AskALawyer.com is a very loyal sponsor to the channel. Same people that brought you eSign and eForms. Amazing company. I support them. I'm the national spokesperson for them, evidently. And I just want you to know that askalawyer.com is an effective way to get legal advice for a cheap price, $49. And they have live lawyers there to either help you with a problem or dispel the myth that you didn't have a problem. You know, if you don't have a case, that you need to know that too. Or if you're doing your own legal research, they have an AI component trained in all the 50 states. Go to askalawyer.com. Okay, without further ado, and this has got 5.7 million views, so that's pretty decent, I guess. So now, Skrill is from the Kensington neighborhood of Philadelphia, and if you know anything about that, it's the fentanyl capital of Philadelphia, Zombieville.
Here in Kensington with my man Skrilla.
We in Zombieland. Hawk spit about the whip, swerve. It's Zombieland like a motherfucker. I love it. I love Kensington.
And if you look here, he's got something in his stomach, smoke, I guess. And he's also got, looks like he's got a little lean there. With the glizzy, though. What's a glizzy? Pop.
When I walk up in this bitch, I do the true step, Brody. Put that crouton on the back of the glizzy.
Put that crouton on the back of the glizzy. The crouton is a switch. You know what a switch is? A switch is a device that takes a semi-automatic handgun and makes it into a fully automatic handgun, making it a federal offense. And so, you know, one of the first things I said when I watched these videos, you guys admitting to making a handgun. But is it art? In the last RICO trial I had, they jammed this video about the highs and the lows up the client's ass, and they played the whole thing throughout. And the judge, I'm going to decode blah 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 blah. I mean, that's just poetry in motion, isn't it? It's just absolute poetry. How you started fucking with that doggy, you can't lie about it. Essentially, what he's talking about is the doggy is heroin. Pulled over, caught a case. Then he started preaching. In other words, he started snitching.
And then he started preaching. Woody changed his life.
Woody changed his life and went to church, and then he turned to a deacon.
He went to church and then he turned to deacon. I done seen a gangster turn.
I done see a gangster turn a wankster, no apparent reason.
Turn a wankster, no apparent reason. I done hit the doggy with the trank and then it made it decent.
I hit the doggy with the trank. In other words, so essentially he's altering the heroin and making it better. You know, when you read these lyrics instead of just uttering them because it's got a good beat, it's really sick when you think about it. Bitch, I'm fucking with that da 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 da. Okay, look at this. So here he is in the video. Here he is riding dirty in this video, and he's got. Was that a prop gun? Oh, it's a prop gun. Do you think he's eligible to possess a firearm? If not, it's a 5-year mandatory minimum. If there's a switch on it, forget about it.
Dog, you can't lie.
I jump out of the whip and you blah, 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 blah. I mean, the guy sounds fucked up, doesn't he? Doesn't he sound like he's already on lean or something? So what can we take away from this video? This uplifting kind of, I don't know, don't you just see bright sunshine when you hear this? What can we take away from this? We can take away that he's got lean, or certainly looks like he's got lean, sitting there. He's talking about boosting up the doggy with the xylazine. We've got him with the Draco sitting there in his front seat saying, you know, we got one person for the blah, 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 and we got another person to move the brick. We don't have any positive pro-social activity here going on, do we? We don't have any building. We have just taking away. Fucking A. And these are the guys that are going to wind up. This video, if he's popped for anything close to this, anything, this video comes into evidence. Pure and simple. Came into our case. All right, so the next one is Bar for Bar by Baby Osama. She's a fairly new artist, but let's just, and I don't know anything about both of these are cold reactions, by the way. Cruising crashed like a test dummy. I'm a grown lady. Well, I can see that. Very handsome lady. Her teeth look all fucked up because they're blue.
Put
that pussy on his face and take his bitch away. I don't think your pussy's that good to be able to say that. He's hating on you. Nobody's hating on you. And I don't think anybody really gives a shit what you say. So I don't think anybody cares if you sign an NDA or not. But I will have to say that it's got a good rhythm, doesn't it? It's got some good rhyme. It's a little gross. Oh, here we go. One taste of the cocaine. God, what do we have if we don't have drugs in these videos? What do we have, honestly? And everyone is self-snitching. When you hear a woman say, I just want the money, 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 believe her and leave her. I'm talking to all you men out there, young men, vulnerable men, older men, younger women. I want the money, believe them and leave them. Consent. Baby, sign an NDA. Fuck. Oh, believe me, if they don't consent, don't do it. Okay? It ain't worth it. Go to the bathroom by yourself. Take care of yourself. Wipe it off. And then you were like, oh, I'm glad I did that and I didn't do that. For shooters only. You know, this Drilla stuff just never ceases to amaze me. Because, and now, you know, it's evolved. Because we're seeing it in cases constantly. You know, we're seeing the judges allow, like in my trial, we had 5 defendants. And, you know, it was a 3-week trial. And the judge let the whole video in. Had nothing to do with my client. But my client gets painted with the same brush regardless. Unbelievable. And, you know, and then the things that they're talking in these videos. I sound like an older white dude. I know I do. Okay? But I see the tomorrows. You guys don't see the tomorrows. I see them. Because I remember we started talking about whether they were going to allow rap lyrics in trials. I had a trial. Federal trial. My client's looking at 30 to life because of this. And they let this shit in. So if you're a little banger, if you're a little gangsta, you know, they're coming for you. The feds are mining social media. They're cleaning up neighborhoods. Things that used to be state regular crimes are turning into federal RICO crimes. They're using what was created for the mob against gangs. And it's happening in your neighborhood as we speak. So if you are a little banger, a little wankster, and you gotta live, you know, you gotta be on the block, you gotta post up. Do something else. It's short money. It's absolutely 100% short money. Watch The Equalizer 2 with Denzel Washington. You watch him talk to this young black guy about short money. Watch his little speech about that. You watch him, you know, this scene that he goes into this den of drugs and guns, and he brings the young man home, and he gets him in his face, and he's talking about short money, and he's talking about this kind of shit. You know, killing people is not cool. Posting up, blah, 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 blah. I mean, that guy sounded so fucked up, didn't he? I mean, it's not cool. You know what's cool? Taking care of your own. Not having to look over your fucking shoulder. Not doing drugs. Being sober. You know, having a baby that you fucking take care of. And take care of the mother. And not fucking around on her and having like 80 other women, you know. A cock was made for one woman. My point in telling you this is that life can get really complicated when you don't meet your responsibilities. And it doesn't have to be that complicated. So do what you got to do to keep your people happy and try to avoid the street life that's portrayed here in both of these videos. This didn't really become real for me until I tried this RICO case. There was a section in North Minneapolis called the Highs, and that's where my group was from. And they had this area that if you went and sold drugs there, you would have gotten shot unless you're part of these guys. They have one of their guys gets shot, they're duty bound to go kill one of the other ones. It's just insane how the murder that's going on, and that's not cool. And guess who fucking picks up all the pieces? It ain't the dads, because guess where the dads are? Dads are usually dead or in prison. In these situations, it's the moms, the aunties, and the sisters. I had a client that was in jail. He lost his mother and his sister. Mother to natural consequences, but his sister to gun violence. He couldn't do a damn thing about it because he was in prison. Well, guess what? What are you going to be doing? If you can't take care of your own because you're in prison, then you're worthless. And if you're in prison right now, think about what you're going to do when you get out. Try to get out and be somebody. Be somebody fucking boring. You don't have to have a training day tricked out cutlass. Drive a fucking minivan and put your kid in the back and take him to soccer practice. Honestly, or football practice or whatever. Just be a boring, solid person in your community. Ugh. So when I watch this stuff, it seems like, it's just, whatever. It seems cool, right? I see the hardcore implications of what happens here. And it ain't pretty. So, with that lecture now said, and certainly ingrained in your brain and your psyche, you're going to make better choices, aren't you? We'll see you next time here at Criminal Lawyer Reacts. I'm Bruce Rivers, your board-certified criminal defense lawyer. Make sure you subscribe, follow us on Instagram, follow us on Twitter, sign up for Patreon, go to clrbrucerivers.com for all your merch needs, and we'll see you next time here at Criminal Lawyer Reacts. This guy's uncomfortable. I don't know why I'm talking about this. Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Do I Like Baby Oil or Do I Like Baby Oil? No, it's Criminal Lawyer Reacts. Sorry, I just got sidetracked there. No, we're reacting to a little bit of a juror misconduct kind of issue with Diddy. But before we get to that, this is brought to you by Grandma. Yes, AskALawyer.com. AskALawyer.com is a very effective way to get legal advice. For $49, you log onto their website and you talk to a living, breathing human being, lawyer, and they can give you legal advice on any kind of problem that you might be having. Like, let's say your grandma living in your grandson's basement and he's not treating you properly, or you don't think he is. Well, you can call the lawyer and get, for $49, get advice on how to get your grandson to treat you better. Or maybe if you've got a issue with a vehicle you sold, or maybe you've got an issue with somebody you want to sue on a contract, or whatever you need, go to AskALawyer.com. These are quality folks because guess what? They're the same folks that brought you eForm and eSign, and they're long-standing sponsors of CLR. So please go to AskALawyer.com, and if you're doing your own legal research, they have AI trained on all the 50 states. So AskALawyer.com. I'm their official spokesperson, which is true, actually. Okay, so there's this dude. It's Inner City Press. He has kind of a good handle on things, so we're going to watch this video real quick. I'll react to some of the things he's saying, and then we're going to do a deep dive on what this all means.
Matthew Russell Lee, Inner City Press, here at the Southern District of New York Courthouse. Today, Thursday, July 10th, 2025. Now, believe it or not, there is yet more news on the U.S. versus Sean Combs front.
Why is he walking? Why doesn't he have a little office or something?
Yesterday, Judge Subramanian docketed an order to both sides to provide him with not argument, but a list of cases in which defendants have been convicted under the Mann Act without prior convictions, basically wanting to know what the precedents are.
So there's a section called 3553A, 18 U.S.C. 3553A, and it lays out a list of factors that the judge should take into consideration when determining a sentence. And one of those is disparity in sentencing. The Mann Act is not really considered a really high-level conviction, right? Everybody's a possible 10-year conviction or 10-year prison sentence. Bullshit, he ain't going to get 10 years. But if you look at where he's at, it's you know, it could be anywhere from in the 50s, and we looked at it, and depending upon how the judge fashions the guideline calculation with all the factors set in, it could be a significant sentence, but it's not going to be 10 years, and it's not going to be consecutive, I don't think. So the judge wants to say, how have we treated these in the past?
The government is going to be arguing that relevant conduct should come in, and the defense is going to be saying no.
Relevant conduct is all the other shit that he was acquitted of. You know, the torturing of Cassie, and Cassie's part of this because who were the prostitutes for? They were for her, so he could watch her. Who wants to watch another man fuck his wife, honestly, or girlfriend? Not me. I just think you got to fucking screw loose when you do that, especially if you have 1,000 bottles of baby oil.
And citing a Supreme Court recent decision about acquitted conduct not coming in. Now, the question is some of this conduct not actually acquitted, but simply out there and in the ether? We'll find out as it moves along. Now, ironically, yesterday we went to cover a civil case not against Sean Combs, of which there are many of which are being pushed back, but we'll have more on that anon. But against L.A. Reid. Yes, L.A. Reid. Drew Dixon sued him in 2023 here in the SDNY. And he's changed lawyers a couple of times. And yesterday, his new defense or current defense lawyer, who's trying to get released from the case, came to court in front of Judge Vargas, who also has the Drake versus UMG case. So she kind of has something kind of a music portfolio of cases. And L.A. Reid's lawyer said he's not paying. In fact, he changed his phone number and they were unable to speak to their client, L.A. Reid.
That's fucking frustrating. When you take on a criminal case, you get your dough up front. Why do you get your dough up front? Because guess what? If you don't pay your lawyer, he can't withdraw from your case. That's a bad business deal on his decision. The juror notes from 25 won't follow instructions to no verdict on RICO to we have the verdicts. But if you remember, the first day, within like minutes, the court came back, or the jury came back with a question and asked the judge and told the judge one of the jurors isn't following instructions. Then they go on to deliberate for some time, and they had a couple different questions. But one of the questions was, we can't come to a verdict on RICO. So the judge said, well, think about it overnight, come back and deliberate in the morning. Well, right away in the morning, then they had a verdict. So what's the issue? The issue is whether or not there is a juror that was not following the instructions. So let's take a look at the Diddy verdict post, or the Diddy docket post. So alternate juror number 6, UN employee George, who lied about not knowing he was an alternate, also says that the jury didn't follow instructions. Is he lying about the jury not following instructions, or could this be a contributing factor to the verdicts? You know, here's the thing. They don't know that the jurors don't know that they're the alternate. Okay, they don't know until the judge says, okay, now they're going to go back and deliberate. Juror number 25, you are the alternate. You will not be going back, but stay where you are because I want to talk to you after this. That's what they say every time. And how is the alternate selected? It is the last juror picked. So when you do jury selection, the last juror to be questioned and then selected as a juror is the one who is the alternate, or last however many. You know, once they get to 12, they have 2 alternates. The last 2 are picked are the alternate. Now here's the verdict form: racketeering conspiracy, not guilty. I mean, that's a good verdict for him. Count 2, sex trafficking of Cassandra Ventura, not guilty. So they must have bought the consent argument. And the Mann Act, transportation, Cassandra Ventura, guilty. Sex trafficking of Jane, not guilty. And then you have the other Mann Act related to Jane, and that was guilty. So the big question, and somebody had already written this, but so the big question is if the alternate jurors were talking to the jurors who are sitting, well, they're all going to talk. You know, it's whether they whether they started deliberation or started forming an opinion before they get the case. That's really the issue, and so it's whether or not it would trigger a Rule 33 motion. Well, they're gonna file a Rule 33 motion anyway, because they're gonna want to see if they can get rid of those two counts. In fact, I'd be shocked if they didn't already file that. So a Rule 33 motion is a motion for a new trial, and they got to file that within 14 days of the verdict. So that's going to get filed. Here's the long and short of it. You know, and they're going to have to question these jurors individually. If they didn't follow the judge's instructions, first of all, you can't go back and do anything about the acquittals. That's hard and fast. It's not appealable by the government. It's not appealable by the judge. The judge can't overturn an acquittal. That is sacrosanct. It is done over. He can't be tried again for those counts, no matter what. No matter what. But the judge could overturn the two verdicts of guilty. That would be reviewable. So after a verdict comes back, if the judge overturns a verdict, notwithstanding the jury's verdict, then that can be appealed by the government. They're going to make a motion for a new trial. They're going to make as much stink as they possibly can about the jurors who were not following the instructions. I mean, they have a note saying juror 25 was not following the instructions. So what does that mean? I don't know what it means, honestly. It's to what degree, you know, somebody's not following. If all of a sudden, you know, you just took a shit while everybody was deliberating, you know, and you just weren't there for that part of the deliberation, well, that's not really significant, right? But if while the case is going on, you're forming opinions and trying to make other people form their opinions, and you aren't doing what the judge said you're supposed to do, you're supposed to keep an open mind, and you know you're trying to sway the jury your way because of whatever reason, well, that would be juror misconduct, and that would be grounds for a new trial. You think they would try this again? I doubt it. So to put a little more teeth into what we're talking about, let's take a look at the clip of the interview with the juror.
You saw some very graphic images, videos. You heard very sexual and graphic details. What was that like, hearing that, and how did it impact how you viewed the case?
No, they were very graphic, and but I think overall, you know, we were looking at it from like one side, and it was definitely riveting and eye-opening.
What did you see on the videos? You know, the press wasn't able to see it in real time.
Yeah. No, I mean, they were showing some of the. Well, I mean, it was both the freak-offs and hotel nights, as they were called, from both of them. But it was.
What did they show in those videos?
They showed, well, again, you know, the defense and the prosecution showed different clips, so they were very selective. Like the prosecution was showing more, you know, just Cassie just sitting around.
The defense showed that?
Defense showed that, yeah.
Just her sitting around not engaging in sexual activity?
Yes.
For the prosecution, when you had to have your headphones on and otherwise, what were you seeing then?
There was sexual activity, but I mean, it wasn't really.
Was it forced?
No, it didn't seem forced. It was actually like pretty tame.
Really?
Yeah.
Did she?
It was just a lot of rubbing oil and stuff on there.
This guy's uncomfortable. I don't know how to talk about this. You know, when it comes to sex, you know, we have a lot of sexual images. You know, sex sells beer, sex sells cars, sex sells tanning lotion, sex sells everything. And we got porn all over the place. But guess what? When it comes time to talk about sex, we're pretty damn fucking uncomfortable about it. You know, I mean, the other thing that he said during that interview was that he took it in stride. You know, basically, he didn't say that, but I mean, he essentially did, and he says it was pretty tame. And it didn't have the impact that one would think. You know, we were led to believe, you know, we didn't see any of the tapes, you know, or the recordings. So, but we were led to believe that these are beatings, that there's all kinds of shit going on, that non-consensual people are screaming. And from what he's describing, and you put those along with the text messages that Cassie was sending, that I can't wait for the freak off, I can't wait for this or that. Whatever, So and there's more to that than what's just right here. But the defense is now going to try and see if they can poke holes in this verdict. They're going to do that by two ways. One, saying that there wasn't enough evidence to convict him. And number two, that the jury was tainted. And if the jury is tainted, we have to have a new trial. And so that's when the motion for a new trial. But they have to do that within 14 days of the verdict. So that'll come up pretty soon. So we'll see. And then they've asked for an expedited sentencing hearing. So that'll be coming up. I think they have a date in October, but they're asking for an expedited sentencing hearing. And the judge wants an array of cases showing how these cases have been sentenced in the past. In other words, with this 3553A factors, I don't want a disparity in sentencing, just because he's Sean Diddy Combs. But I am going to take into account relevant conduct, the violent conduct, the pervasive nature of all this shit. This isn't your average Mann Act case. Your average Mann Act case is where you get a prostitute that comes in over state lines, and it's, usually consenting adults, but it's still illegal. And a one-time offender is not going to go to prison over something like that. However, this has got a lot more yuck factor to it, wouldn't you think? And so the next step for Diddy is file a new motion for a new trial, interview these jurors, get your Rule 33 motion done. They also have to get a motion or a memo to the judge on sentencing disparity, how these cases have been sentenced in the past. And then they have to meet with probation, do a pre-sentence report. They have to file a sentencing memorandum. This is what we think should happen if you don't give him a new trial. We think he should be released immediately, and this is why. And the government will say he should get 56 to 87 months or whatever, 56 to 78 months, whatever they think is the appropriate sentence. We'll keep following this. Make sure you subscribe. Follow us on Instagram. Follow us on Twitter. Sign up for Patreon. I have all these things for you to do. How do you have any time to do anything else? Honestly, make sure you have your wine at the ready. Make sure you have your popcorn at the ready for the next episode. And go to CLRBruceRivers.com for all your merch needs. Get some hoodies and hats and all the goodies. And we'll see you next time here on Criminal Lawyer React.